Better. Of course, this way. Okay. Good morning, ladies and gentlemen. I'll call this recommending committee meeting to order. Right, Terry. Today, June 2nd, a little bit after 9 a.m. Staff are we in compliance with the open meeting law?
We are.
Okay, with that being said, I would like to move forward to the first line item of business today, and that is Bill number 2009-21, which updates the hearing procedures of the municipal code relating to parking infractions, proposed by Bradford R. Jerby, City Attorney. Staff?
Yes, Committee. This bill is something that we have proposed to help update our parking infraction collection system. Heidi Almasi from the City Attorney's Office is here, and she's going to make a brief presentation about what this bill is about.
Heidi? Please come to the microphone and state your name and address and social security number for the record. Minus the social security number.
Heidi Almasi, Deputy City Attorney for the City Attorney's Civil Division. What you have before you today, folks, is a proposed ordinance change to the our parking ordinances. What it does is it basically requires that any person who would like to have a civil hearing, which is to say a judicial hearing, instead of either paying their ticket or going before the hearing master down in parking, they have to post a $500 bond. What this does is it provides a mechanism for municipal court to set the hearing. In the event, what we've seen in the past is people requesting the judicial hearings and then nothing happens on the ticket. It just basically sits. We don't have a process. So this is the beginning point for setting a process in municipal court for them to hear these hearings in the event that a person wants to have a judicial hearing instead of availing themselves of the arbitration. That money would be posted, the hearing would be set, and then in the event that there was a fine assessed, it would be subtracted from that amount, and then the remainder of the money returned to the party. If, on the other hand, there was a finding of no responsibility or not guilty, all of that money would be returned to the party who posted it.
How fast does the unused amount have to be returned to the person?
In my experience on the criminal side, usually if it's a credit card, it takes 6 to 8 weeks. If they post cash, it's fairly immediate, within about probably 2 weeks.
6 to 8 weeks? Why?
That's just processing. That's just the process with credit cards. We see that.
That used to be the process with credit cards. It's much more efficient than that.
That's just based on my experience down in criminal.
What is the nature of posting the bond? Or let me ask this question. Let me ask the question in this respect. Person A receives a parking ticket.
Correct.
And the amount of the parking ticket.
Parking tickets can vary anywhere from $20 to about $250. Our highest fines are assessed for parking in front of fire hydrants, fire zones, or for handicap violations. And what we're seeing is that we have a lot of chronic offenders. I mean, I've got tickets ranging from balances of $2,500 to $9,500 for our chronic offenders, and we're not getting them into court. They're basically applying for a judicial hearing, and it's not being set. So we're trying to get that process set so that we don't have these cases lingering.
If it's set, is it a no-show? A lot of them are no-show?
Yes, we're seeing a lot of no-shows.
Then what happens on no-show legally?
Well, when we have where a person has requested either an arbitration hearing. Hi, Mark. How are you?
I just want
Sorry. If they've requested either a hearing master hearing down in parking or a judicial hearing, they've selected one of the avenues that they want. So if they don't show, that amount is rendered to judgment, and that gets sent to collections.
It's a collection issue then?
Yes, or if they go to a hearing and a deal's made and then they don't pay on it, it also goes to collections.
Mr. Vincent, would you like to say something?
Yes.
I don't like that.
And Heidi can correct me if I got this a little skewed, but when we went to the administrative process with a hearings officer, the intention was to keep these out of the court system. I mean, we didn't want to be dealing with adjudication of parking tickets in a court system.
Right.
But they still have the right to do that. What's happened, it appears to me, is that people have recognized that if they elect the judicial avenue and don't see the hearings officer, they found a loophole where these tickets are dying. And
They're what?
they're dying. They're not getting adjudicated, and we're not collecting the fees. And so what happens is if they don't get scheduled on the court's calendar, they're dismissed. We collect nothing. And so the idea here is not to prevent someone from
Getting lost.
doing the adjudication process if they want to see a judge, but to make sure they're serious about doing that and not just using it as an avenue to avoid paying a parking ticket. And that's kind of where the genesis of this is coming from.
Well, you're at the microphone. Could you answer that question about why it takes so long to get money back to people on a credit card?
I can't. I would think that if the credit's processed immediately, it should be pretty quick.
That's right.
I can't speak to the credit card systems, you know. I mean, it's not like we take 3 weeks to process the credit. We
No.
process the credit immediately.
It used to
and
be
then-
that way, but it isn't anymore. And that's why I was asking if there's anything in here about how fast the people get their balance back.
Well,
Because you're going to have war over this if it takes that long.
Yeah, I'm not sure that I know, but I wouldn't be opposed to something that would require us to process the refund, be it a check in the mail or the credit card, within a week. And then beyond that, it's up to the system.
My experience with it has been is the city personnel processes it immediately, but because it's credit card and it's billing cycles, we don't have control over that end. And if it's improved, just with technology, that may be the case. I know on the city side, we're doing it as quickly as we're notified.
Obviously, there's a billing cycle issue, so you may not see it show
You
up
may
in your
not see
statement, but that doesn't mean the credit wasn't
That's
processed.
right. We need to take
Because
the action.
those of us who might look at credit card activity online know that those things get posted pretty quickly.
They do. Okay. Well, we probably should have something to that effect.
But anyway, I wanted you to understand that was part of the genesis here, is that we feel that people have discovered a loophole in the process, and we were losing some substantial revenue from tickets because these would go to a black hole.
Who ultimately dismisses cases that fall in the black hole? How is that done?
Any case where a judicial hearing has been requested in municipal court goes to the city attorney's office. Now, my practice has been, since I took over about a year and a half ago, is to make an offer to negotiate these matters. Again, municipal court's got a high volume. We're trying to handle it on the front side. This isn't dissimilar to what would happen with the criminal deputy. I make an offer, probably, Sherry Bonnet's here, I would say maybe half of those tickets negotiated at half the face value of the ticket. The remainders that we have, we're starting to set in municipal court. And then for our chronic offenders, those are the ones that are considered bootable, or 500 or more. And frankly, the balances I have on those are about 2,500 to 9,500. We're going to litigate as a collection matter.
But is it your office that dismisses those that fell into the hole?
Only the ones that are referred to the city attorney's office.
Only those?
Yes. And those are the ones where judicial hearings are requested, or they are a chronic offender.
Okay, all right.
So is the bond to the stopgap, placing the bond, the $500 bond, is that how we are moving forward or recommending to move forward to close up that
Yes.
loophole?
That's correct.
Okay, so let me back up one step behind the bond. If you will, just walk me through the process up to the bond in the sense of point A, person A receives a ticket. What happens after that point? What steps happens after that?
Under the ordinance, a person has a couple options. If they get a ticket, they can just pay it, which is an admission. They can request what is basically an arbitration hearing with the hearing master down in traffic, down in parking. I'm sorry. And they go down and they make their case and a decision's made. By ordinance, the hearing master can take into consideration several factors that might result in a reduction in the ticket. Decision's made, and the party then pays or the case is dismissed, depending on what the hearing master decides. Or the party can request a judicial hearing, in which case they fill out a form that's provided in parking that says, I want to avail myself of a judicial process. Then the case, Sherry and her crew put the case together and they send it up to the city attorney's office. We use a civil process, which means that we have to serve a complaint. We draft a complaint, we have to serve it on the party. They have 20 days to issue an answer. And once that's done, we can then request that municipal court set a hearing, and basically it takes place as if it were a trial, but it's a civil trial, not a criminal trial. And then judge makes a decision one way or another.
So I followed you, but at what point does the bond fall into place at that point?
Under the proposed revision, once they elected for the judicial process, they would then have to post the $500 bond. Then, because we affect service, I mean, we have to get a process server, there's things that we do on the city side. We draft a complaint, we serve that on the defendant, respondent, and then they have 20 days. And they would have to file their answer with municipal court. And then you'd be looking at a hearing, depending on municipal court's calendar, probably anywhere between 3 to 6 weeks.
So would the city issue the bond at that point, or would they have to go out to an outside party in order to get a bond?
They would have to go to an outside party. City would, to my knowledge,
Yes.
we don't do bonds.
The only thing I'd add to what Heidi said was that if they elect the hearing officer option, they waive the right to the judicial. That's sometimes a little confusing issue, but if you elect to go see the hearings officer, you are waiving your right to have it adjudicated in the court.
Oh, so they have an option to either the
They
hearing
have-
officer or the judicial?
And they have that option today.
Okay.
They have that option today. If you elect to see a hearings officer, you waive your right to see a judge, to adjudicate it. All we're trying to do in this particular case is creating a disincentive for people who are working the system to say, well, I don't want to see the hearings officer, I want to adjudicate it, so you get a $20 parking ticket that goes in a black hole that nothing ever happens out of it. So we're trying to create an incentive or disincentive, if you
So
will.
the $20 parking ticket, they have to put up $500 bond if they want to go on. True?
That's correct. But what we're seeing is we're not seeing your typical $20.
That doesn't happen.
Yeah, we're seeing people that are stacking, and what's important is that once it goes to the city attorney's office, once your judicial hearing is corrected, there's a fail-safe in there, in that I look at the ticket, and we'll sometimes, depending on the nature of the ticket, if this isn't a case where we have somebody who's stacking their parking tickets, we'll make an offer to negotiate. And my standard offer, as long as there aren't any sort of aggravating circumstances, is I offer half of the face value of the ticket. So, the city attorney's office, we're responding to those people. They call in, they check with us, we send them a letter, I get the phone calls. If there's something mitigating where they want to talk about it, I'll dismiss it if the facts warrant it. Sometimes we stick with the offer and they say no, and then they get a hearing, but it's a very rare case that we have just somebody with a $20 ticket who's going forward to the judicial hearing portion of it. More frequently, what we have is someone who's stacked a lot of violations.
Right. Is our process connected to the DMV?
Yes, I mean, and staff here can explain it a little better than I can, but yeah, we do have certain windows of opportunity where we can put holds on DMV registrations, and we use that, but there are limitations in the system to that, so sometimes we're not able to do that, but where we can, we do.
Where is that threshold? At what point is the DMV triggered?
If they've, for example, requested a hearing master adjudication of the ticket, and they don't show up, or they don't adhere to whatever the negotiated resolution was, there's non-payment. Then, once there's non-payment or non-action, we have the option of suspending the registration of the vehicle that was assigned that parking violation. What we're seeing, though, with some of our chronic offenders is they'll get a stack of violations, their registration gets suspended, so they have somebody else register the vehicle, or they just stop registering that vehicle. So it's become sort of this clogged process.
When we had a expose done on parking ticket collections a couple of years ago, the leading #1 offender actually said to the reporter that, well, I just register a new car. That's all I do with that. So, there's...
If I go through the judicial process, will there be court costs on me, including the process server, everything else? Do they have to pay for that process?
As of right now, municipal court doesn't have a civil filing fee structure. What they have adopted thus far is the Justice Court Rules of Civil Procedure. And when I spoke to them about a year ago, Muni admin was talking about adopting justice court's filing fee structure. But in this particular instance, the costs up front are borne by the city because we file the complaint and we have to effect service on the defendant. So there's a possibility that if a defendant, for example, wanted to counterclaim against the city, that's a new lawsuit, so they would have to file a fee in that instance. But if they're just answering our complaint, then I don't believe they would have any filing fees.
Really?
Yeah.
That doesn't seem right.
Same as in family court, it's a civil action.
It's
If I
costing us to go after this.
Exactly.
Big
Exactly.
time.
Exactly.
We can't get any of it back. Any of the cost part.
Well, Sherry Bonnet and her crew have been very effective. I mean, parking, I think, generated, what, 2.3 million last year?
Yeah, we're above 3 right
Yeah.
now. Yeah.
But what does it cost us to chase this person that wants to go to court ultimately?
Well, if you take the typical action of a $20 ticket, which is why I've adopted a policy of looking at them and making a negotiation on the front side, basically it's going to the city attorney's office and we're expending legal hours to go after a $20 ticket.
Yes.
But that's not the typical case.
No,
The typical
that's-
case is somebody who stacked their violations. That's the more common.
I think there's a lot of time involved and a lot of process and whatever involved in the big person to get him into court. And the judge doesn't go, okay, you owe $3,000 plus court costs, right? They don't say plus court costs.
Not at this time, no.
Well, how do we change that? I mean, that's something we ought to be going after, it seems to me. If somebody's gonna put us through this circus, it seems to me that they should pay for the circus and everything related to it.
Well, that's part of the bond process. We're trying to get rid of some of that problem. One of the other things that parking, we do have administrative assessments that go into some of these tickets.
But the bond process relates to what they owe, that's gonna go towards what they owe in the adjudication,
Correct,
correct?
yes.
And not to the cost. You may wanna think about it. It seems to me it's a lot of work and we're not gonna get paid for it.
We just,
Chasing the people.
well, we're doing everything we can to, affect collection in the
Well,
traffic or
I'm
parking.
not criticizing what you do a good job at your end, and you're trying to improve it by having the $500 bond, but the reality is, we're spending a lot of money to chase these people. And it seems to me that the court system's set up that you pay court costs on certain things. So that would be my,
Any more comments?
no?
Okay. At this time, we're down to the public. Is there anyone here that wishes to speak on this item? If so, please come to the microphone at the table and state your name and address for the record, please.
Good morning. My name is Teddy Russell, the fifth, Siegel Suites, Teddy Drive in Sahara, Las Vegas, Nevada. They named it after me, of course. Is it Councilman Steinman that is the chairman? I haven't been here for a while. Oh,
Barlow's the chairman.
Councilman Barlow, how
I
excellent.
just talk too much, that's all.
Through you, Mr. Chairman, the only thing I'm not clear on so far, as has been presented, although I'm entirely in favor so far, what would happen in the case of the failure of the ticket holder to, how long do they have to get the bond, and what is the action should they fail to get the bond?
Staff?
Thank you.
Essentially, in response to his question, prior to our filing a complaint, they would have to post the bond. So city attorney's office wouldn't take any action until that bond was posted.
Does person A have an opportunity, if in fact they can't get the bond, to come back and request to be heard before the hearing officer?
Yes, that would be the other option. That would be the default option, or pay the fine.
Any additional questions?
No further questions. This merely reflects the excellence of our city attorney's office. It's amazing how good news travels in the more criminal elements of the community. This is going to be a revenue enhancement, and it's going to be a fair warning to citizens that would abuse the city of Las Vegas. I do recommend approval, and thank you.
Thank you. Is there anyone else wishing to speak on this item? If so, please come to the microphone and state your name and address for the record.
Yes, good morning. My name is Jose Monroy, 2830 Lockbroom in Henderson. I'm here because this ordinance, I think, is unjust to the people that don't have the money to go to the bond. I think we're giving the opportunity to the people that have the money to post the bond, which I wouldn't do. I'd just have to give the $500 because of a $500 bond is $50, and you're fighting a $20 ticket with the $50 bond, which is, I think, doesn't make sense monetarily. So I would give the $500 bond. However, we've been saying that there's loopholes. I think the loopholes are on the side of the city, not on the side of the people getting the citations. If there are a few people that use these loopholes to their advantage to circumvent the system, then I think we should enforce and go after those people and not penalize the small guy, the little guy. I mean, I got a $20 citation, and I wanted to go through the judicial system because I didn't feel comfortable, and not in any way speaking derogatory about a hearing officer, but I do recognize the fact that that hearing officer works for the Department of the Citations, and if he's going to be giving decisions against that department, they're going to get another hearing officer. I didn't feel right going to a hearing officer that works for the department that gave me the citation. I had asked for a court date, and I applied and turned it in, and I got my receipt dated August 19th, 2008. I haven't gotten the court date yet. If I would have given if this ordinance would have been in effect back then, I would have had $500 tied up for, 9 months now. And I don't think it's fair to the public that unjustly gets a citation to have to pay, like 20 times the amount of the bill, because 25 times the amount of a $20 ticket, because we fail to go after these people that always have the citation. And there are enough procedures in our ordinance that allows us to go after them. I know they can still get around them, but you can't register your car if we have the boot. You find them, instead of giving them another citation, put the boot on it. You can deny them their state licenses if they're doctors and attorneys. And I hate to say this, but a lot of attorneys accumulate a lot of tickets because of where they have to work and where they park, and then they're taken care of. Well, I'm just here because of the little guy. I'm here not as a city employee, but as a citizen, and it does, by the way, affect city employees because we drive unmarked cars. We get citations for parking. Well, in fact, I'll give you an example. I was giving somebody a citation for doing something illegal in front of our court, and while I was giving him a citation, the city vehicle with exempt plates was getting a citation. And that's the $20 ticket I was fighting. There it is, my receipts dated August 19th, 08. And I don't think it's fair that the little guy has to pay $500 bond because we're not being efficient enough in going after the other people and using the ordinances that are already on the books. And if I could, I'd like to just address, how many court cases are we talking about? I haven't heard whether it's something that is a huge amount that it is really becoming ineffective. And again, I think $500 for a $20 ticket is ridiculous. And I also think that we're trying to penalize the little guy again. And I think the judicial system should be open to everyone. regardless what it costs the city, hey, negotiate before you're in there, do whatever you have to do, but don't take away a right that a citizen has in our city. That's all I have. Thank you.
The gentleman did ask a question. You're fine to go.
I'm sorry?
I said, you're fine to go. I'm just talking about a comment that you made in regard to one of your questions. The gentleman asked a question as far as what is the number of court cases are we talking about on average as far as in the system now? Can someone respond to that?
Do you know how many you submitted this year?
I didn't check that before I got here, I'm sorry.
I couldn't give you an exact number. I can tell you that when I came on board about a year and a half ago, I did an audit, a caseload audit for myself, and we had several hundred parking tickets that were sort of languishing in this limbo. One of the first things I did was we cleared out our caseload. Anything that was old, didn't look like it was worth prosecuting. Some we made offers on, and again, we go through those cases one by one. I do that, and we make an offer on those before we ever elect to go forward with the judicial hearing. And part of that is give the benefit of the doubt to the person that got the violation, give them an opportunity to speak to us. Same thing we do in criminal court, although this is not a criminal matter. But we do make an offer to negotiate each and every one of these tickets unless there are some aggravating circumstances. For example, I have a couple cases where it's 4 or 5 handicap parking violations. In those instances, we don't necessarily make an offer to negotiate. We'll leave that to the court. Give somebody an opportunity to have their day in court.
Right. So would they have to post a bond also, or do they automatically go
No,
to?
this would be perspective only. Everything that we've got in the hopper right now, we're going through them case by case, making offers, talking to the people, and then we've started setting aside those cases that are going to go forward into the municipal court system. We have answers. Just this last week, we've had a couple answers filed, and we're getting ready to get court dates.
So if let's just for example, if a senior citizen pulls up to a handicap parking stall and in the midst of whatever happening, that person gets a ticket, maybe due to them not displaying the placard or in another vehicle that the placard is not assigned to, but it's placed, or whatever the case may be, that will draw a ticket to that senior. And that senior opts not to move forward with a hearing officer and want to move forward to the judicial side, the civil side, to hear to speak to the judge directly. Would that individual have to post a bond in order to get to the judge?
One of the things I do as a matter of practice, and I don't anticipate that it would change with our office, is we look at those cases and we make an initial contact with correspondence. We send them a letter. They get my direct line. If they have something that they want to offer, we'll make an offer to negotiate in that letter. And a lot of times I get contacted, and depending on, I've had people that say, look, it was a mistake. I was doing this, this, and this. And we're like, all right, fair enough, and we dismiss it. And we do that before we go to the trouble of filing the complaint, which if the ordinance the change were adopted, we would still be doing that. We would still be looking at these cases on a case-by-case basis. Attorney makes a decision to make some sort of offer to negotiate it. If we got to the point where they're like, nope, I want my day in court, then they would post the bond. And as mentioned, it's not, usually when you post a bond, you post a percentage.
Correct.
So,
It's $50 on $500.
correct, 10%.
So in essence, the question to my answer is, yes, the senior would have to post a bond in order to have his or her day in court.
If we got through all of that stuff and they said, yes, I still want my day in court, then they would post the bond, and then we would file the complaint and effect service on them. They have 20 days to respond. Once we receive their response, city attorney's office does a motion to place it on calendar so that we can get a court date. One of the things about municipal court is their case management system only addresses the criminal calendar. So everything that we're doing on the civil side, we do manually. So the city attorney's office we do the motions, we actually contact a person down in municipal court, and we get a court date. It's not automated. So.
Can I ask, the gentleman was up here earlier. How did that little $20 fall through the cracks? And is this an example of how they fall through the cracks?
I don't know the particulars of the gentleman's.
I don't know exactly
Yeah.
what he did, but
One of the issues that we've had is that these cases have been forwarded for judicial hearing to parking. And, you know, I think it was one of those things where it went on and on and on, and we didn't address it timely. One of the issues when we started talking to municipal court about it was the lack of this automated system. Everything's automated now, so when you go up to Muni and it's non-automated, you're kind of starting from scratch. And that's not Muni's fault, it's just one of the system is built in, and we're working with it, and we're trying very hard to make sure that each and every one of these tickets is either addressed personally by me or one of my legal secretaries, or we send out a letter to the person if we can find them saying, look, we've dismissed your case. We're in the process of, and I think we're pretty up to date right now. So
I think we should review his case, but that's another side.
Okay.
But the issue here is, I appreciate what he said about the small person and $500. However, this is targeting another person. This is targeting the chronic person that's trying to get through the system, beat the system, and so on. That's really what we're after in establishing this bond or this $500 you have to put up. It's not attempting to target the small person. That's what I'm hearing today. Is that correct?
That's correct.
We really want to clean up the big ones. And if they're going to go to court, they're going to court, and they got to put up the money to do it. But he does bring up a good point here.
Yes.
Of he would have had to put up $500. It would be sitting there 9 months. Now what? So, in all fairness.
If I can address, this situation is different because we have an employee who believes they're acting in the course of duty. We've made it perfectly clear throughout the city that other than peace officers, our employees are not exempt from complying with Las Vegas code. And so and we have told people, this has been going on for a couple of years now because we had quite a few employees stacking up tickets for parking violations that they were parking where they were not authorized to park. We've done a couple of things, and that brings up an interesting issue, and that is we have allowed, by policy, we do allow departments to make a value judgment that if they feel that this was in fact something that was appropriate in the line of duty, the department can pay the ticket out of their operating budget as an operating cost, and that has happened. And in fact, I think this particular ticket, it was paid by someone other than the employee. So we have policies that deal with that, but by and large, I mean, the law is that employees are not exempt from complying with traffic laws and parking laws. And so, that's a unique issue. That's a different issue than what John Q. Public's going to be experiencing.
Well, for me, it's a matter of, I think, personally, that it's a very good ordinance. However, it does affect some individuals who feel as though they want their day in court and having to expend additional dollars can be a hardship. So I'm not in favor of it as far as the way it stands right now. So we can take it to a motion at this point, sir.
Well,
that you have
first of all, there's a
recommendations.
couple of issues here. One of them is returning the money in timely fashion after the hearing with the judge. But then the other one is, how do you treat the person with the $20 ticket versus the person with $9,000 worth of tickets? Is there any way to write something in that relates to a certain trigger point in which that $500 bond kicks in?
Could we graduate the bonds
Yes.
based on the value of the offense?
Yeah, up to a certain point, there'd be no bond. It was $100, I don't know, whatever, the smaller one. And then you click in at above a certain point, and you have to put up the bond to go to court. Now, that brings us to trying to protect the small person that feels they were judged wrong for a little ticket of $20 or 30 or 40. So I see, those are the issues here that I see. And we can, I don't know, Val, how we handle something like that, changing this when it's supposed to be council tomorrow, I believe.
No.
2 weeks?
No, we can study it some more. Let me make a suggestion about the return of money issue. If there's a problem in municipal court now, we ought to talk to municipal court about addressing that. If it's not a problem, this ordinance isn't a place to fix it, in my opinion. The court, to some extent, is a separate arm of government, and we're reluctant to impose on them our rules
By ordinance?
by ordinance when they have court rules that are probably, if not specifically, probably implicitly dealing with the return of monies and filing fees and all that other stuff. So I would suggest that we find out if there's a problem, and if there is, have them fix their rules.
All right.
As it relates to a graduation of a bond, we can look at that, I think, keeping in mind that a portion of the bond is to make sure someone's serious. It's not supposed to reflect the value of the tickets. And I appreciate what the councilmen are saying, that some people will be affected by it, but that's the purpose of it. When this, in the year that the city council decided to take this out of the criminal arena and put it in civil, we knew that there were going to be glitches. We'd never done it before. We knew we'd be coming back. It took us a long time to come back. We're coming back and saying what we wrote X number of years ago isn't working as it relates to judicial hearings. Here's our attempt, but we can look at it some more. The county still does these criminally. We could always go back to that. And when you're in a criminal case, you don't pay any fees, but nobody really wants these that I know of in the criminal arena. So my suggestion is we can hold this in abeyance and work on it. You can send it to the council with a no recommendation, and we can work on it in the interim, whatever you'd like to do.
You came forward, you have something to say?
Yeah, I'm Sherry Bonnet. I'm the supervisor of parking and hearings. And over the last 3 years of being there, I'm the one who actually sees the final paperwork on the civil hearings. And I take an interest in looking at it, looking at the history of the individuals that file these civil hearings. And I can tell you that in most cases, they are chronic offenders. A good example, we have one gentleman that knows that he cannot park in this 1 hour zone more than an hour. The minute he gets the ticket, he walks in, fills out the form, even before the ticket gets in the system, and says, I want to go to, for a civil hearing. This is what we're trying to stop. It's getting out there on the streets. I mean, once you start doing this, there have been times where people have been in our lobby and other people said, don't do the hearing officer, do the civil hearing because they won't get to you, it goes away. It's getting out there, and we need to be a little bit stronger in our collection effort. As far as the hearing officer, he is a third non-biased party. He is hired through a contract. He doesn't make any extra money if he rules against or for. And for the most part, quite honestly, he dismisses more than he makes them pay. I mean, the percentages are up there, and I can provide those for your office. We do give everybody the chance. It's a parking ticket. It's $20. Yes, if you want to go to a hearing, that's fine. But why should we tie up the city any longer for just a $20 ticket without making them responsible for going through the process of paying for our services for that? When we have a hearing officer, we also pay. They can get in within a month to 2 months with the hearing officer, and it's a lot less cost to the city.
You said paying for our services?
Pardon?
Paying for our services? That's what you just stated.
I'm sorry, I maybe...
You didn't mean that, I don't think.
No.
She meant paying for the cost of.
Yeah, paying for the
collection
cost,
effort.
Yes.
Yeah, paying,
I wish they
we're-
would pay for our
Yeah,
services.
we're tying up Heidi for a $20 ticket for someone that has 5 of them, and because he knows he can let it just get lost in the system, why shouldn't we say
Well,
to
I think
him?
we learned that this morning.
Exactly.
It's lost.
And that's what I want to stop. I mean, we're about collecting on valid tickets. Our officers aren't out there just giving tickets because they're not valid. There are times, yes, that we need to find out the circumstances involved, and we will work with them on that. But I feel that this will stop those chronic people, and I am definitely for this as the supervisor of the parking
For
office.
this as it relates to $500 on a $20 ticket?
Yes, I am.
You are?
Yes, I am. The time that our office has to take on that $20 ticket and processing the paperwork, we'd be better off just to let it go before it gets to the city attorney.
I have a question. Can we place the parking officer, or at least the parking tickets in a position, whether it be through ordinance or another means, where that's the end versus going the judicial route?
You mean not give a judicial option?
As far as setting the system up in a way to where there's mechanisms in place, however, the point of, the end point will be, whether it be the judicial hearing officer, not the judicial, but the hearing officer, as far as the end, or,
You're saying not
and
having...
no option for the
Right,
judicial.
we can look at that. I can tell you that when we started this process, there was some thought that because it's a civil violation, we need to have the ability for someone to go to court if they want. The thought was, we don't want to tell people they can't have a judicial process at all. We can certainly look at that again and see if that's still a concern, but it was back then. And so our thought was, we're going to give people the right, if they want to go to a faster process, which 95% of them will, we're going to make them waive their right to a judicial hearing. So that's what we do. That's what they do when they ask for it. We can look at going completely non-judicial, but the thought at the time was that some people out there are going to say, this used to be a crime. I used to be able to go to a court. It's the same act. You've made it civil. I still want to go to a court. And so our thought was, we're going to leave that option there. Like I say, we can look at it some more.
Okay, and the other option I was thinking of is forcing them to go through the hearing officer. And should they want to go further after the hearing officer, then post a bond at that point versus the option of hearing officer versus judicial.
That, we can say that too. I think the thought was, this is not a big enough deal to set up a multiple level of appeals. It's just, it doesn't make sense, in other words. For someone to be able to start one level, then be able to appeal it to another level, and appeal it to another level.
Right.
We do that with crimes, obviously, but in the civil arena, it's small enough, it's...
Well, right now, the way I look at it is, if I have an option to go to the hearing officer or the judicial side where the loophole exists, I would go the judicial route as well. But if I have to go to the hearing officer, which basically will take me more time as an individual, and then have to file an appeal to go to the judicial, maybe that will avoid a lot of that, or make them take an additional step to think about it versus just bypassing the hearing officer completely. That would be my thought at this point. I'm ready for a motion.
I'll make a motion to obey this item so that all the issues brought up this morning can be studied further.
All in favor?
Aye.
I'm sorry.
Pardon?
30
For 30 days?
30 days?
30 days.
30 days.
I'm a short termer, so what the heck?
Yeah, today is your last day.
That's true. No, I gotta do the next one.
Oh, you do?
Yeah.
Oh, okay. All right, then I'll have a good speech for you.
Yeah, thank you very much.
All right. Thank you.
Okay.
All right, now we're down to bill number 20022, which updates the business license provisions of the municipal code by adding certain administrative and services related fees and adjusting various license fees and license origination charges, sponsored by Councilman David Steinman. Is there anyone here wishing to speak on this item? Please state your name and address for the record.
Councilman Barlow, Councilman Steinman, Jim DeFiore, Manager of Business Services, 400 Stewart Avenue. We'd like to hold this item, Bill number 2009-22, in abeyance for 2 weeks for the next recommending committee meeting. We have met with the industry staff as recently as Friday, and the comments that were submitted verbally and in writing to us over the last couple of days will bring forward a First Amendment to this particular bill, and we are not prepared to go before the recommending committee today with those amendments. What we'd like to do is propose in 2 weeks that we would come back with the First Amendment with the industry meeting that we had, and those that attended will have a copy of that First Amendment when they come to the recommending committee meeting 2 weeks from today, better prepared and for discussion, and certainly allow us to better prepare the council members for discussion on this particular bill.
Okay.
And I would say that I met with Jim yesterday after his meetings on Friday and made some suggestions, and I think this is the proper way to go to get this in the right form.
Okay. Is there anyone here wishing to speak on this item? If so, please approach the microphone and state your name and address for the record. Hearing none. Councilman, you have a motion?
I'll make a motion to obey this item for 2 weeks.
2 weeks is the motion. All in favor?
Aye.
Aye. So moved. Thank you. And bill number 200923, which updates the city business license fee provisions to increase the gross sales license fee, include for certain license categories annual fee adjustments based on the consumer price index and the city's growth rate. Adjust license fees for certain alcoholic beverages licenses and add provisions regarding the licensing and regulations of persons who rent or lease certain types of commercial property, sponsored by Councilman David W. Steinman. What's all this sponsorship? You're trying to...
I think others were avoiding.
Okay.
Put the sacrificial
Great
lamb
answer.
up.
Great answer. Staff.
Councilman Barlow, Councilman Steinman, Jim DeFiore, Manager of Business Services. Again, this bill would be recommended to be held in abeyance for 2 weeks for the same reasons as I commented on for the previous bill.
Hearing that, is there anyone here wishing to speak on the item? If so, please come forward and state your name and address for the record. Seeing none.
I will
Councilman, do you
move
have
to
a
obey
motion?
for 2 weeks.
2 weeks is the motion. All in favor?
Aye.
Aye. So moved. Now we're down to citizens' participation. Public comment during this portion of the agenda must be limited to matters within the jurisdiction of the committee. No subject may be acted upon by the committee unless that subject is on the agenda and is scheduled for action. If you wish to be heard, please come to the microphone, give your name for the record, the amount of discussion on any single subject, as well as the amount of time any single speaker is allowed may be limited.
Good morning. My name is Teddy Russell, a resident of Las Vegas. I don't know why everyone's leaving. The fun's just about to begin. I did want to tell you of my great joy and satisfaction that we will have a new city hall. I realize this is not in your jurisdiction necessarily per se right now. I was very blessed in that I saw the end from the beginning and made comments accordingly at the last time I spoke before City Council. The measures proposed by Culinary were extraordinarily weak. I was rather surprised that it needed to be elevated to the august level of the great state of Nevada Supreme Court. Nonetheless, I consider that we are entirely blessed. I realize that I might be recommending a busman's holiday, but I encourage you to visit the official City of Las Vegas website and see KCLV Channel 2, 360 Degrees of Las Vegas, celebrating 50 years of the Las Vegas Convention and Visitors Authority. I do believe, and I think the citizens might have the last word here, the gentleman from Henderson was in exact earnest. It was something that it is not the target of this bill. And also, I would remind you that the city attorney's office has said that there were negotiations, this and that. Actually, the proposed measure is a last resort, and the bond is merely an indicator of earnest. I thank you very much for your time and for your indulgence. I have to go now to Clark County Government Center and take care of them also. Thanks so much and have a great day.
Thank you. Yes, anyone else wishing to be heard?
Good morning. My name is Deborah Deegan. I am an intern at Ricky Barlow's office, and I believe that this meeting was very productive, and I'm glad to see that there are being ordinances made upon the traffic and parking problems that we have.
All right, thank you. Is there anyone else wishing to be heard at this time? Hearing none, this meeting is adjourned. Mr. Russell, what are you gonna do about that wiggly tooth up front?
I keep on,
Look,
really, you have no idea.
why don't you just pull it out? I have some
No.